I want you to take a second and just imagine a scenario.
Okay, I'm listening.
But set aside the usual science fiction tropes, right? Picture a situation where the world's major global superpowers, along with, heavily funded private corporations, aren't locked in a standoff over shipping lanes in the South China Sea.
Wrote the usual terrestrial flashpoints.
Exactly. They aren't negotiating over rare earth minerals in some mountain range on Earth. Instead, the focus of their geopolitical tension is water ice.
Oh, yes.
And this water ice is buried inside the freezing, pitch-black craters of the moon.
The visual that comes to mind with that is, it's almost cinematic. You picture massive excavators kicking up lunar regolith, corporate logos stamped on the sides of these pressurized habitats, and diplomats aggressively negotiating exclusion zones, hundreds of thousands of kilometers away from Earth. But the reality we are analyzing today is that this scenario is actively making the leap from theoretical engineering to immediate international law.
And that is exactly our mission for this deep dive.
Welcome in, everyone. Today we are exploring a really fascinating set of excerpts from a source called The Final Frontier, The Geopolitics of Lunar Mining Law.
It's a great collection of texts.
It really is. The core focus here is how humanity's sudden and massive expansion into space is violently colliding with the current framework of international law.
Violently colliding is a good way to put it.
Right, because we are moving from an era where space was treated strictly as this pristine realm of scientific discovery to an arena of hardcore commercial and strategic competition. The rules governing the cosmos are shaping up to be, probably one of the most complex legal battles of the 21st century.
Oh, absolutely. We are entering a frontier where the pace of technological and economic development it's completely eclipsing the legal frameworks we currently have in place.
It's moving so fast.
Exactly. The rules that will dictate how humanity extracts resources beyond Earth are being tested and in some cases circumvented right now, largely because the economic incentives have suddenly become just too massive to ignore. So let's break down those incentives. Because for decades following the Apollo missions, the moon was largely treated as like a dusty museum.
Right, a scientific curiosity.
Yeah, it was scientifically interesting, but commercially inert. So what is the actual catalyst driving these corporations to view the moon not just as a destination, but as critical infrastructure?
Well, the catalyst is water.
Just plain old water.
Just water. But to understand the economic shift, we have to look at the mechanics of why water is so incredibly valuable in a vacuum. On Earth, water is everywhere. We take it for granted.
Sure.
But in space, it fundamentally alters the tyranny of the rocket equation.
The rocket equation meaning the math of getting things off the ground.
Precisely. Currently, the most significant bottleneck for deep space exploration, like if we want to launch a crewed mission to Mars, is lifting mass out of Earth's gravity well.
Because every kilogram of payload requires multiple kilograms of fuel just to escape the atmosphere.
Exactly. That exponential math makes deep space travel prohibitively expensive. You're basically carrying the weight of your own fuel. But if you have water on the moon, you suddenly have a solution.
How does water solve the fuel problem, though?
By deploying solar arrays on the lunar surface, you can generate the electricity needed to run an electrolysis plant.
Okay, and that splits the water.
Right. That electrical current splits the H2O molecules into liquid hydrogen and liquid oxygen.
Oh, which happen to be the primary propellants used in modern heavy lift rockets.
You've got it. It effectively turns the moon into a massive refueling depot operating in a fraction of Earth's gravity.
That's wow. It completely rewrites the orbital mechanics and, frankly, the financial models of exploring the solar system.
It changes everything.
Okay, let's unpack this for you listening. It's a bit like trying to sail across an ocean, but instead of having to pack all your groceries, your gas, your lumber for a round trip on day one, you discover a fully stocked supply station just waiting for you halfway across.
That's a perfect analogy. The impact on payload capacity is just staggering. And water is merely the most immediate resource. The sources we're reviewing also delve into helium-3.
Right, the helium-3 argument.
Yes. So Earth's magnetic field largely deflects solar wind, but the moon has no such shield.
It just takes the full brunt of it.
Exactly. For billions of years, the lunar regolith has been bombarded by solar winds, trapping isotopes like helium-3 in the soil.
Which is highly sought after for neutronic fusion, right?
Yes. From an engineering standpoint, if we ever crack commercial fusion, helium-3 is the absolute dream fuel.
Because it's clean.
Right. It doesn't produce the dangerous radioactive waste associated with current nuclear fission or even standard deuterium-tritium fusion.
But there's a catch, isn't there?
There's always a catch. Helium-3 is trapped in the lunar dirt at parts per billion concentrations. Extracting it requires strip mining massive swaths of the surface and superheating the regolith to release the gas.
So it's not exactly easy.
Yeah, not at all. But even with fusion technology still decades away, policymakers and corporations are mapping out these deposits today. They are thinking long-term.
And when you add in the necessity of in-situ resource utilization, like using local lunar basalt and dirt to 3D print habitats rather than launching steel all the way from Earth, you have a complete economic ecosystem waiting to be claimed.
A very lucrative one.
But that creates an enormous legal paradox.
It really does.
Because if you have corporations preparing to spend billions on solar arrays and electrolysis plants and regolith harvesters, their first question to their legal team is going to be about property rights.
Naturally. They want to know they own what they're building on.
Right. Which sends us all the way back to the 1967 Outer Space Treaty. And, reading through these sources, it is jarring to see a treaty designed for the geopolitical climate of the 1960s being applied to modern corporate mining.
Well, if we connect this to the bigger picture, the authors of the 1967 Outer Space Treaty were primarily focused on preventing the orbital deployment of weapons of mass destruction.
Yeah, they were terrified of nukes in space.
Exactly. They wanted to stop the moon from becoming a theater for military conquest. They were designing a framework for state actors during the Cold War.
Not CEOs.
Right. The concept of a private aerospace company mining ice for profit simply wasn't on the drafting table.
So they created a framework that essentially hangs a giant do not touch sign over the entire cosmos. I mean, Article 2 explicitly forbids national appropriation.
Yes, the non-appropriation principle.
It establishes space as a global commons, meaning no sovereign nation can claim territorial ownership over any celestial body. Planting a flag doesn't mean you own the moon.
The treaty completely dismantled the terrestrial tradition of exploration, where planting a flag equated to claiming a continent.
Right.
It also established, under Article 6, that sovereign states bear international responsibility for national activities in space.
Meaning what exactly for a company?
It means a private corporation cannot claim to be a rogue entity immune to the treaty. The nation where they are incorporated is legally on the hook for their actions.
So what does this all mean for the companies we just talked about? If a modern CEO analyzes this treaty, they see an absolute ban on owning the land.
Correct.
But zero explicit rules about owning the rocks or the ice sitting on top of that land. If you legally can't claim ownership of the territory, how on Earth, or off Earth, I guess, can you justify spending billions to mine it? How are corporate lawyers exploiting that silence?
They rely on a legal interpretation that our sources refer to as the maritime analogy.
Okay, the maritime analogy, how does that work?
The argument draws a direct parallel to the laws governing the high seas. Nobody owns international waters, right? The ocean itself is a global commons.
Sure.
However, if a private commercial fishing fleet sails into those waters and hauls in a catch tuna, international law recognizes their lawful ownership of those fish.
Okay.
They are completely free to process, transport, and sell them for profit. By this logic, nobody owns the moon, but whoever extracts the resources gets to keep them.
Okay, wait, I have to push back on that.
Yeah.
That analogy seems incredibly fragile when applied to the moon. I mean, a fishing fleet is mobile. They pull up their nets and they move on.
True.
Extracting water ice from a lunar crater requires permanent infrastructure. You have to bolt a processing plant to the ground, set up landing pads, deploy acres of solar panels. If a company parks a multi-ton industrial facility on top of an ice deposit, they are functionally occupying that land.
That is a very valid point.
How are international courts supposed to swallow the fishing analogy when the reality looks much more like building a fortress?
Well, that exact friction is what critics call practical ownership.
Practical ownership, meaning they own it in practice, if not on paper.
Exactly. The counter-argument asserts that large-scale, continuous resource extraction naturally creates an exclusion zone. If a corporation establishes an active mining operation inside a crater, the physical realities of operating in space demand that they keep competitors at a safe distance.
Here's where it gets really interesting for you listening. Imagine you are a competing aerospace company analyzing this situation. If your rival claims a 10-kilometer operational radius around the only accessible water ice in a specific region, haven't they basically created a monopoly over that crater?
Functionally, yes.
They aren't flying a sovereign flag, but if no one else can access it, it's de facto ownership.
Yeah.
They are dictating who can enter that territory.
And the distinction between owning the land and controlling access to the land becomes purely semantic at that point. Critics argue this violates the spirit of the non-appropriation principle established in 1967.
That's a massive loophole.
It is. We are left with a profound deadlock in international law. One camp views resource extraction as a fundamental right analogous to fishing, while the other views it as a backdoor land grab that threatens the concept of a global commons.
And since the United Nations framework is essentially paralyzed by this debate, individual governments have decided to stop waiting. They are bypassing the international consensus entirely to write their own rules and protect their own domestic industries.
Yes. The sources point to 2015 as the watershed moment for this shift.
What happened in 2015?
The passage of the U.S. Commercial Space Launch Competitiveness Act. That legislation was a deliberate move to provide legal certainty to the market.
How so?
The U.S. government explicitly recognized the right of American citizens and corporations to own, transport, and sell extracted space resources.
Wow, so they just unilaterally declared it legal.
Essentially, they walked a very fine legal line, explicitly stating that the United States was not claiming sovereign territory, but they formally validated the extraction of the resources themselves.
So they legalized the catch while insisting they didn't own the ocean.
Exactly. And from a purely market-driven perspective, you can see why they did it. Without that domestic legal guarantee, venture capital dries up.
Right, you can't finance a billion-dollar lunar harvester without the absolute assurance that you can legally sell the harvest.
Precisely. And it didn't take long for other nations focused on the space economy, like Luxembourg, to draft similar frameworks to attract aerospace headquarters to their borders.
But this unilateral approach, where every country makes up its own rules, inevitably leads to intersecting national interests, right?
Right. Which is why we saw the introduction of the Artemis Accords in 2020.
Okay, let's talk about the Artemis Accords.
The Accords represent a U.S.-led effort to create a multilateral framework through a series of bilateral agreements with partner nations. They emphasize transparency, the interoperability of hardware, and the peaceful use of space.
Okay, on paper it sounds highly cooperative, very noble.
It does. But what's fascinating here is a specific mechanism buried in the Accords that our sources identify as a major polarizing flashpoint: the introduction of safety zones.
Safety zones. That sounds innocent enough. Why is it polarizing?
Well, the Accords propose that to prevent harmful interference, operating entities can establish safety zones around their lunar infrastructure.
Okay.
And supporters argue the physical environment of the moon necessitates this. There is no atmosphere to create drag. When a landing vehicle fires its thrusters, it accelerates lunar regolith outward at ballistic velocities.
Oh, I hadn't thought of that. The dust essentially acts like a shotgun blast of microscopic glass shards.
Exactly. It can obliterate the fragile solar arrays or sensitive optics of a neighboring facility. Consequently, proponents say safety zones are just a basic operational necessity. They provide predictability and prevent catastrophic accidents between competing operators.
But looking at this critically, a safety zone operates remarkably similarly to an air defense identification zone on Earth.
In practice, yes.
I mean, a nation might not claim sovereign ownership over international airspace, but they absolutely demand to know who is flying through it, and they control the parameters of engagement.
Right.
It serves as a highly polite, legally palatable form of territorial annexation. You draw a circle around the most valuable real estate and restrict entry under the guise of safety.
And the ambiguity surrounding the enforcement of these zones is what really alarms legal scholars. The Accords state that the zones should be proportionate to the operation, but who determines that proportion?
Good question.
If two rival corporations want to mine the exact same crater, and one sets up a safety zone that encompasses the entire deposit, there is no established international court to arbitrate that dispute.
And this isn't just a theoretical debate spanning the entire surface of the moon, right? These legal maneuvers are preparations for a very real, very physical clash over one specific location.
Yes. The tension is incredibly localized. It's specifically zeroing in on the lunar South Pole.
Why there? Why is all this legal maneuvering focused on such a small geographic area?
It comes down to a unique topographic anomaly. Due to the moon's very slight axial tilt, the sun remains low on the horizon at the poles.
Okay.
This creates deep craters that exist in permanent shadow. They haven't seen sunlight in billions of years, making them perfect cold traps for pristine water ice.
That makes sense. But extracting that ice requires massive amounts of power. I mean, you can't run an industrial mining operation on battery reserves alone.
Exactly, and this is where the geography becomes highly restrictive. Right next to these permanently shadowed craters are elevated crater rims, often called peaks of eternal light, that receive near constant solar illumination.
Wow.
To mine the ice, an operation must secure one of these illuminated peaks to place their solar arrays and then run power cables down into the dark crater below.
Okay, let's piece this together. You have an overwhelming demand for water ice, intersecting with a microscopic supply of locations that actually offer both the ice and the sunlight required to extract it.
High value plus limited spots equals fierce competition.
It is an engineered recipe for geopolitical friction. And this time, it isn't just nation-states maneuvering against each other like in the Cold War.
No, the operational landscape has completely fractured since then. Today, private industry dictates the pace of launch cadence, the development of orbital infrastructure, and the innovation in extraction hardware.
The companies are moving faster than the governments.
Much faster. State space agencies are increasingly acting merely as customers, purchasing services from commercial entities.
So we have a 1967 treaty designed to stop nuclear war between governments, being stretched to govern 2020's corporate entities, all funneling toward a few specific peaks and craters at the lunar South Pole.
It's a perfect storm.
What happens when the inevitable occurs? Say a private company's autonomous drilling rover suffers a navigation failure, right? And it crashes into a rival corporation's solar array, wiping out their power grid.
It's a very real possibility.
Who actually acts as the space police? Who investigates the collision? Who assesses the damages? Who enforces the penalty?
The short answer, we currently have no mechanism for it.
None.
None. There is no international lunar police force, nor is there a designated commercial space arbitration court with the authority to enforce a ruling. The legal frameworks are entirely terrestrial, attempting to cast a shadow over an unprecedented extraterrestrial environment.
That's terrifying.
When highly capitalized actors compete for incredibly scarce, high-value locations without a binding referee, the resulting tension will invariably cascade back into geopolitical conflicts here on Earth.
Which brings us to the crucial final section of our sources, the crossroads of governance. How do legal scholars propose we manage this frontier before it devolves into just, chaotic, unregulated extraction?
Well, several frameworks are currently circulating in international law symposiums. Some scholars advocate for an international licensing body, something similar to the International Seabed Authority, that would allocate extraction rights and ensure equitable access.
Okay, a licensing board. What else?
Others propose comprehensive resource registration systems. This prioritizes transparency so all actors know exactly what is being extracted and from where.
Makes sense. Keep a public ledger.
Right. There is also a push for stringent environmental oversight to prevent irreversible contamination of these ancient lunar environments, alongside the establishment of specialized commercial arbitration institutions tailored to the unique physics and economics of space.
Those all sound like rational solutions. But the reality on the ground, or I guess on the regolith, is that none of these proposals have achieved anything close to universal agreement, right?
No. They remain entirely theoretical discussions. The fundamental crisis here is the discrepancy in velocity between engineering and diplomacy.
Technology is officially moving faster than the law.
By a wide margin. The aerospace sector is actively assembling the launch vehicles and the extraction hardware today, while the international legal community is still debating the semantic definitions of treaties drafted half a century ago.
It is staggering to conceptualize the scale of this disconnect.
Yeah.
I mean, the moon sits nearly 400,000 kilometers away, right?
Right.
It serves as this constant visual reminder in our night sky, yet the legal uncertainty surrounding it is staring us right in the face today. It's an immediate terrestrial problem.
It forces us to ask whether humanity is capable of designing a preemptive, cooperative system of governance, or if we are simply destined to repeat terrestrial mistakes and export our fragmented, hostile competition into the vacuum of space. It represents a unique historical inflection point. For perhaps the first time in human history, we are attempting to establish the legal architecture of a new frontier before the primary wave of expansion actually arrives, rather than just reacting to the chaos and conflict after the fact.
And that leaves you with a final provocative thought to turn over in your mind long after this deep dive concludes. If international law consistently trails behind the pace of technological innovation, what happens to humanity's collective ideals if a private corporation manages to establish the very first extraterrestrial monopoly? Let me rephrase that.
Take your time.
What happens to the concept of space as a global commons if a private corporation manages to lock down that very first extraterrestrial monopoly before the ink on a new comprehensive global treaty is even dry?
The resolution to that question will likely establish the precedent for how humanity interacts with the rest of the solar system for centuries to come.
Thank you for joining us on this deep dive into the legal frontiers of the lunar economy. It is always a privilege to unpack these complexities with you. Until next time, keep your eyes on the horizon and keep questioning the rules that govern the future.
Subscribe to Ambat Legal Insight and stay legally informed with clear, practical, and reliable breakdowns of the law. Follow our channel and activate the bell icon so you never miss important legal updates, case analyses, and expert insights that matter to every citizen. Support our mission of spreading legal awareness by liking, sharing, and commenting, because your one action can help thousands become more legally empowered. Join the ALI community today across YouTube, podcast, and social platforms and take a step toward understanding your rights, your laws, and your justice. Ambat Legal Insight, because law is for everyone.